And we're back on the Real Estate Junkies. Today's topic is something very special, dear to my heart, might be disassociated from the regular residential type, but it is touching a lot of people that are listening right now. So we're talking about investment property issues, and there's a lot of them. So today, with this in the studio with me, my buddy Rami Rahmanian, attorney at law. Rami, how you doing?
Hi, Nick. Nice to see you again.
Good to see you.
It's like I just saw you 10 minutes ago.
It feels like it, doesn't it?
With a different shirt on.
Yeah, in a different shirt that gets tighter and tighter all the time. So anyway, forget about that, right? Now, we're talking about investment property issues, and there's plenty of it. Any person out there that had some extra money to invest into the right thing, which would be property,
Right.
is facing those issues. Whether they're a small owner of a small single family, single house that they're renting out, that they purchased as an investment property, or they have 3 or 4 units, or they have 50 units, they have issues. And those can be pretty hard.
Right.
So where do we start?
Well, these days, a lot of people who buy or invest in property are doing so to supplement their income with rental income.
Mm-hmm.
They're becoming landlords. And a lot of people who are becoming landlords for the first time may not know about some of the pitfalls associated with that.
Yeah, and a lot of people are. A lot of my friends invest. I got some investments and so on. So you got tenants in there, which causes a lot of liability right to start with.
Right.
So where are we going from here?
Well, I think the most important thing for first-time landlords to realize is get everything in writing. Make sure you have a written lease in place with your tenants. Now, it may seem basic and elementary for some, but you'd be surprised at how many people establish these tenancies, let people live in their property without a written lease.
And I have seen everything from a one-page lease written with hand, but hand, to 70, 80 pages of a custom lease on commercial property and so on, owned by institutional lenders and so on. So what is the most common situation? What type of a lease do you recommend, or what type of thing do you see out there that needs fixing?
Well, for a lot of landlords who don't want to go through the time and expense of consulting with an attorney every time they get a new tenant,
Right.
there are pre-printed lease forms that they can use. There's some put out by the California Apartment Association, or you can talk to your realtor. A lot of these forms have been vetted by attorneys. They're updated constantly, and they contain a lot of the more common lease terms, such as the rental amount, who pays for utilities, maintenance issues, all of those things. So for somebody who's diving into something like this for the first time, using a form like that from a trusted source is probably the best way to go.
Yeah, and I have to do my plug in here because constantly on an everyday basis as a realtor, I meet people that have done it by themselves and that contact me only at the point where I have to bail them out of trouble.
Right.
And they're asking, oh, our lease says this and that. Well, they should have spoken with me prior to writing the lease. Now, realtors obviously are trained, especially commercial realtors, people that are involved in that, to use proper forms. The California Association of Realtors has the proper forms. If those are not used, attorneys can put them together to protect the clients as well. But you do need a good lease to protect the side that you're working for.
Absolutely. And another area that realtors really can make a big impact is even before you get to the point of signing a lease, and that is in screening your tenants.
Of course.
It's very important to screen your tenants beforehand so you don't get into trouble later. Now, of course, if you have a bad tenant, one who doesn't pay rent, you can always evict them, but there's cost and there's time associated with that. And by screening, what I'm talking about is doing a background check, a criminal and a credit check, and also verifying their employment.
Yeah, that brings up a cute story. I don't know if it's cute or not, but the fact is I have a prospect, a friend. I wouldn't call him a client because we never had anything signed, but a person that asks me questions quite frequently. And he owns a lot of property. And like some people, he thinks that he knows it best and that he's the only representative of his best interests.
Right.
So he goes out and looks for tenants. Now, I just got to tell you a story on that because of the fact that in order to save money, not to pay a realtor to do that and pay the commissions due, he goes through the screening process. And unfortunately, what I see is every 3 months, he has a new tenant. because by my standards, he is taking the wrong type of tenant based on his opinion about the tenant rather than on the facts.
Right.
Where we base our opinion and suggestion to the landlord based on a hard set of facts and knowing that that tenant is going to be there for a while and pay the rents. So it is, how do you get to these people to explain the benefits of actually asking for professional help in doing it when I know a lot of small owners of small properties doing it all by themselves?
Well, many people do have a very good sense of character. They're very good judges of character, but there's really no replacement for experience, for somebody who's been through the process before and who's seen the things that can happen that maybe somebody who's a good judge of character might not foresee.
Right. So where did the legal issues jump in here?
Well, once, let's say you've picked your tenant, right? You have somebody with good credit. You're ready to sign a lease. One important thing is to always make sure to get a security deposit from the tenant.
Yeah.
Now, there are some issues with that also. You're not allowed to ask for more than 2 months' rent worth of security deposit if it's an unfurnished unit, 3 months' rent if it's furnished. And you have to make sure, if you're in a rent-controlled area, to put that security deposit in an interest-bearing account.
Okay.
Okay?
Everybody wrote that down?
Everybody, I hope you did.
You can replay.
The other-
rewind, play it again.
And
Okay.
another good practice is, whenever you have a new tenant moving into one of your properties, make them sign a move-in sheet. And a move-in sheet is basically a sheet where they record any defects that they see with the property. Chipped paint, a scratch on a doorknob, any of those things that were pre-existing. That way, when they move out, you have a good measure for deducting from the security deposit for damage they caused versus damage that was already there.
Right. And when you got to that point in time when we are actually separating and that security deposit is playing a role versus that check-in sheet,
Right.
how does that work out? Usually, do people kind of feel unfair?
Well, the California law puts certain safeguards in place to give tenants an opportunity to fix these problems before it gets to that point.
Right.
For example, if a tenant is moving out, the landlord is supposed to schedule a walkthrough with them about 2 weeks before they vacate. And in this walkthrough, you go around with the tenant and landlord together, and you identify issues that need fixing.
Right.
This will give the tenant a couple weeks to remedy the problem. If they don't, then the landlord can deduct for those things from the security deposit.
Okay.
Once the tenant moves out, or once the lease term ends, the landlord is obligated to return any unused portion of the security deposit to the tenant within 21 days. And with that, the landlord has to also include an itemized list of things that they deducted for, as well as receipts for those repairs to show that those were actual charges.
Right. Here's a live sample.
Okay.
I know that people won't recognize it, so I can ask you, and maybe you
Sure.
can figure it out.
Sure.
But I'm going to use your time.
Please,
Free.
please.
Free of charge.
Absolutely. For you, anytime.
Right. So you got a tenant that is suddenly turned in their keys and says they're leaving. And they did miss the last month of rent. And they did not make that payment with the return of the keys. And at that point of time, they're claiming that they're leaving because of bug infestation, which yet needs to be proved without making that rent payment. So what do you suggest in that particular scenario the landlord does to handle that situation the best possible way?
Well, again, every scenario depends on the specific facts.
Right.
What a tenant is obligated to do is to first contact the landlord and give the landlord an opportunity to remedy a particular problem.
Of course.
So if there was a bug infestation there before, the tenant was under an obligation to let the landlord know and give the landlord a chance to fix it.
Absolutely.
Only when the landlord failed to do so would the tenant be able to take extra steps, such as what's called a constructive eviction,
Right.
where they give you back the keys and say, no, thank you, you had your chance, you didn't fix it, now I'm moving out, or withholding rent.
Excellent. Excellent.
Right.
All right. So I think one of the key things in this whole thing is geographically placed.
Right.
So you have owners that own property here and there, and some of those own it in rent control areas. So let's touch on that.
Okay. Well, that's a good question, Nick. First, let's define rent control.
All right.
Rent control is basically a series of laws that are in place in certain cities that add certain protections for tenants. So in certain parts of Los Angeles, for example, the units there, the properties there, are rent controlled.
Yes.
And what that means is the landlord is restricted from raising the rent to beyond a certain point, and they're restricted in the reasons for which they can evict a tenant.
And that's why I asked you, because that word rent control rings like really bad with a lot of people. But I think that there should be a better understanding of the pros and cons of owning a property. Because if it was a totally con against and so on, nobody in LA would own property.
Right.
Yet everybody owns it, and they're pretty happy with it. So
Right.
what are the pros and cons?
Well, the pros are that rent control ordinances tend to exist in areas where property is in very high demand. So you do have some restrictions on what you can charge people and how high you can raise their rent. But as a landlord, you'll never be at a loss for interest for renting out that property.
Right. There'll
Okay?
always be somebody.
Right.
to rent.
Some of the cons are, as I mentioned, in certain parts of Los Angeles, you can't raise the rent beyond 2 or 3% every year. And if you want to evict somebody, there are additional procedures you must go through.
Right.
For example, in Los Angeles, you can't voluntarily evict someone when their lease is done. Once their lease is over, they automatically converts to month, and they're able to stay there.
Right.
If you want to get rid of them for any reason, you have to have a specific defined reason in the law for doing so.
Until they leave on their own.
Right.
Right.
One of the more common reasons is for owner occupancy. So let's say I own, or you own, let's use you as the example. Let's say you own property in a rent-controlled area of Los Angeles, and you decide you want to live in that property. The first thing you do is you have to go to the housing department and get permission. You pay a fee. Once you get permission, you have to give them notice, and you have to pay them a certain amount of relocation assistance. This can be anywhere from $8,000 to about $18,000 or $19,000, depending on who they are.
Right.
And then once you move into the property, you have to stay there for a minimum of 2 years. Otherwise, the tenant can come back and sue you for bad faith.
Okay. But have a serious intention to live in that property.
Right.
Obviously. And then the last thing is that when is the chance for you to actually updating property, facelifting and doing all the improvements on the property?
Sure.
Obviously, you have a property that has tenants in it, and the motivation for doing any work on it is very low because you cannot raise the rent, right?
Right.
On the other hand, if the property is taken over because of this and that condition that it's vacant, you can actually do that and change rent.
Right. Well, the rule is if a tenant leaves on their own, if they voluntarily vacate, you can re-rent that property at whatever rent level you want.
Okay.
If you need to update or fix anything in the property that would require a tenant to move out, you would have to relocate them, either temporarily till you make the necessary fixes and then you move them back,
Sure.
or if they want to find another place to live, you'd have to pay them the relocation assistance and move them.
Right. Okay. So that pretty much covers the topic of rent control.
Okay.
Do we have anything else on the topic of
Landlord-tenant?
landlord-tenant?
Right. Well, one unfortunate result is sometimes a landlord has to resort to evicting a tenant. The most classic example is if a tenant fails to pay rent for whatever reason, the landlord has to take certain steps in order to evict that tenant. One thing a landlord may never do is resort to self-help measures. A landlord is not allowed to lock a tenant out of their property. You're not allowed to turn off their utilities or take any steps on your own. You have to follow the proper legal procedure for evicting a tenant.
That is something that you can tell more about, but a lot of people, I notice, do think that they, as landlords, have the right to do that because it's their property. So what is the suggested set of?
Well, for any eviction in California, there are really two main steps. One is you provide notice. So in the case where a tenant fails to pay rent, a landlord must give them a 3-day notice to pay or quit.
Okay.
That means the tenant has 3 days to pay the rent. Otherwise, the landlord can proceed to the next step, which is filing an unlawful detainer action.
Okay.
Okay, an unlawful detainer action is basically where a landlord files a complaint, says the tenant didn't pay rent. They serve this complaint upon the tenant. The tenant has about 5 days from that point to file an answer to either agree or disagree. You have a hearing, And if the landlord prevails and the court finds that the tenant is in violation, then the tenant at that point would have about 5 days to move out.
Okay. And the landlord can file on its own or hire someone to do that for them.
Right. The landlord can file on its own or hire someone to do it. One important thing to note, at any time in this whole process, whether it's at the time a 3-day notice is served, all the way up to the end of trial, if a landlord ever accepts rent from a tenant, it nullifies the whole thing. And if the landlord wants to evict them, they have to start all over again.
Right. Well, you heard it all. I thank you so much
My pleasure.
for
Thank
this
you, Nick.
set of cool things about investment property. You heard it all here on the Real Estate Junkies. Join us next time with another exciting topic. See you later.